Divorce Talk Radio does not give legal advice, neither does it reflect the views of Rockford College. To obtain legal advice, you need to retain an attorney in your own jurisdiction. Good evening, folks, and welcome to Divorce Talk Radio. This is attorney Brad Tengler, and I'm here in the studio this evening with attorney Frank Martinez to talk about DCFS litigation. Good evening, Frank. How are you?
I'm fine.
Thanks for coming. Absolutely. Thanks for coming this evening. You have an excellent reputation.
That's nice of you to say.
Well, and very much true for all kinds of legal work, and specifically here this evening we're here to talk about working and dealing with DCFS. Can you give a brief introduction about yourself?
Well, I've practiced law since 1983, and I've practiced in my own private practice since 1986. And my practice is concentrated in matters of criminal defense and juvenile law, which includes abuse and neglect and matters with DCFS, that's the Illinois Department of Children and Family Services, and matters of juvenile delinquency. So I do quite a bit of litigation involving the department, either directly against the department or in juvenile court where the department is a party, but the state's attorney leads that case.
In terms of all the different ways in which you are working against or with DCFS, can you describe for the audience, how you get involved in these kinds of cases?
More often than not, I receive a phone call from someone who may have gotten my name from a friend or from another attorney or from the phone book or from whatever source my name pops up in. And they'll call and they'll tell me that they have an issue with DCFS. It could be that an investigator knocked on their door today and wanted to see their children or wanted to talk to them and advise them that they've been accused of something. So they get on the phone and they try to locate an attorney as quickly as they can. There are times, and this used to be the case for me, but I no longer am active accepting appointments, but the court itself for an indigent individual may call and ask if I would engage in representation for someone who cannot afford counsel, and then we're compensated by the county. I don't do that as much as I used to, but if the court is in a pinch for an attorney to fill in, I'll be happy to take a case as a favor to the court.
Sure. So just going back a little bit, so you get calls when DCFS comes knocking at people's doors?
Generally speaking, yes, or sends them a letter saying you're now the target of an investigation. So as soon as they get notice, and of course DCFS knocking on your door is scary. It's frightening because people don't know why they're knocking on the door, or at least most of the time don't understand, and immediately have visions of losing their children. And they make requests. DCFS will make requests of them that they may not want to acquiesce to. The first thing we have to do, oftentimes the first thing I have to do, just accepting a call out of the blue, is calm the person down so I can get the facts. It's that traumatic of an experience. So that's how it starts.
And when you say, traumatic experience, what are usually people's concerns? I mean,
Well, their first concern is, why are you here?
Sure.
And why do you want to talk to my children? And why should I let you talk to my children? And what right do you have to come into my house? And those types of things. You have to remember that an investigator from the Department of Children and Family Services is an agent of the government. So when they knock on your door, it's the government knocking at your door. And most people don't like that, regardless of what agency is knocking, whether it's law enforcement or these folks. And oftentimes they may not know why they're knocking at the door. The investigator may try to explain it, but it may be something that they don't want to hear or don't understand. So immediately there's a sense of, there's panic, just generally speaking. Then that's where I get the phone call.
So when people are concerned about why DCFS is knocking at their door, what are the different areas legally that you are involved in with helping parents and or, say, foster parents working against DCFS or with the DCFS?
Well, when somebody calls me, the first thing I normally have to do is we have to talk to them either on the telephone, and if they're going to hire my services, bring them in so I can discuss with them exactly what the juvenile court and DCFS world, for lack of a better term, is. People often don't understand what their rights are, and they don't understand what DCFS's rights are. The Illinois Department of Children and Family Services is a very powerful agency. I tell clients routinely that I believe they're more powerful than the FBI. And this is the story, this is why I tell them this, because if the FBI wants to come into your home and you don't wish them there, they have to get a warrant signed by a judge to come into your home, to search your home and seize anything they wish. Property-wise, they'll seize your computers. If they suspect there's misconduct, they'll seize drugs, guns, whatever. The department doesn't need that warrant. If they get a phone call on their hotline and they form a belief that your children are in danger, or that you're a danger, they will come and take protective custody. They don't need a warrant to seize your own children. And your remedy is you'll be granted a court appearance in 2 days.
So they can just take your children indefinitely?
No, not indefinitely.
So how does that work?
Well, we're jumping the gun here a little bit because we're at the initial stages. If the Department of Children and Family Services, pursuant to an investigation or even just an allegation, believe that your children are in imminent danger for some reason, they have the right to take protective custody of them. They take them into custody and they'll put them with a relative, if one is available, or a foster family, if a relative's not available. You'll be served with some notice of what this danger is and why they can't stay with you. If they're removing your children, that means they believe that you are a risk to those children. And if you contest this, or when you contest this, you can come to court 2 days later. You'll be given a court appearance to come to juvenile court. Because while they can take your children, protective custody of your children, right there, they are accountable to the courts eventually. But notice how this is different than my FBI example, where they have to go to a judge first and explain to the judge the probable cause and get a warrant and come back and seize property. DCFS works the other way around. And all this is legal. And I explain it to clients, and they find it hard to believe that it's legal, but it is. It is clearly legal. So what happens next is that after that hearing in a couple of days, which is typically called a shelter care hearing, it's a hearing that you're entitled to as a parent whose children have been removed to establish probable cause, and I'm going to use legal terms and then I'll define them, probable cause and urgent and immediate necessity. It means the state's attorney has to show some evidence to the judge that shows that there's probably a risk to these children. They probably maybe were molested or injured or beaten or malnourished or not taken to the doctor at all, medically neglected. There's some reason to believe this petition is here. And two, even with the probable cause, that it's of urgent and immediate, those are the words that are in the statute, urgent and immediate necessity to remove the children from this environment. The judge has to make this finding. Sometimes they don't. They return the children right there. Other times, they endorse, they legitimate what the department has done, and then that petition, which accuses you of abuse or neglect, will be set for trial. And so litigation will begin.
So that's not the trial date. That's the initial shelter care hearing date.
That's correct. It's the first appearance. It's the first time you see a judge in court. And it may or may not, and probably not, resolve itself there. But it's the first appearance where you're served formally with the exact allegations that are against you.
I think I heard you say that the burden of proof at the shelter care stage is just more likely than not, probably.
Probable cause.
Okay. And so, judge makes a determination that the abuse or neglect probably happened.
Well, let's correct that. Let me back that up.
Sure.
The probable cause means that there's reason to believe an incident has occurred or that abuse may occur. Probably happened goes to a standard called a preponderance, which comes into play later when the state's trying to prove their allegation. Probable cause is a very low standard. If there's just enough evidence to show that something might have happened, that legitimizes this petition. It doesn't mean that it's granted, it just means it's enough to go forward.
What if there's only a 10% chance that it happened?
It's hard to say in percentages, but I'll give like an example. Someone calls up someone and says, this 10-year-old child said that her stepfather molested her 2 weeks ago. And the department is called, they come to the house, they interview the child or at school, the child repeats the allegation. There may not be any physical evidence of any sort, but just a simple allegation from the child. And that's going to be reported to the court. That's probably enough to get past probable cause. The child will not have to testify and will not testify at this shelter care hearing. The caseworker will testify, or the investigator, that she interviewed the child said this, and that's good enough for the court at the shelter care. At the shelter care.
Is the burden of proof higher at when the court makes a decision about the
whether it happened,
for the petition for neglect, whether it happened?
Yeah, then it is higher.
Okay.
The burden is a preponderance.
And how long do parents have to wait until a judge actually makes a decision about this?
Well, it'll take several months. At the shelter care hearing, a pretrial conference will be set. There is a 90-day limit. So if you hold to that 90 days, you should be able to litigate. Unfortunately, sometimes it takes longer than 90 days for your attorney to prepare a defense. You may not want to take advantage of that 90 days because it may be in your best interest to properly build a case that shows you're not guilty of anything, of any wrongdoing, of any neglect or abuse.
Can you give an example of why people might want to wait more time to build a case?
There might be lab results of medical records, medical evidence that was being analyzed. It might take longer to get records that are beneficial to you than that you wouldn't have if you held to that strict trial date. It's a strategic question. It's just a strategic question. Normally speaking, if the case is set for trial less than 90 days out, in most cases that should be enough. There is the exception where you might want to move to continue and waive that 90 days for any number of reasons. You might have an expert that you're trying to utilize to hire an expert witness who's not available for the trial date, so you need a continuance. But you need that expert.
And so then what happens on the trial date for the petition for neglect or abuse?
Well, the trial date's just like a trial. It's a trial. It's not in front of a jury. It's in front of a judge.
Why can't it be in front of a jury?
Because the Juvenile Court Act does not allow for trial by jury. You're not afforded that right in this civil matter. It'd be interesting if they allowed that. I'm not sure that the social welfare industry would care for that. But there is no right to a judge or a jury. I mean, there is no right to a jury, I'm sorry, in an abuse and neglect trial. It's a bench trial in front of a judge. The state's attorney then has the burden of producing evidence which shows by a preponderance of the evidence, which is more likely than not. Think of it as 51% likely. more likely than not that something happened to the child, something, whatever specifically was alleged. The child was molested, the child was beaten, the child was abandoned, the child was left alone, you know. So that's what happens at a trial. After the state puts their case on, you, of course, have the right to put your case on.
No, these are not criminal trials.
These are not criminal trials.
This is strictly just
they're civil trials. Yes.
To make a determination about whether or not children are neglected or abused, and then how to remedy that.
And how to remedy that, then, yes. The first part of a case is called the adjudication. Adjudication is basically, are the children abused or neglected? Then the second part of the case is called a disposition. And that's essentially, in layman's terms, what to do with this family. It could be that the neglect was such that by the time it comes to disposition, whatever the neglect was is no longer there. It might have been a dirty house. It might have been one of those filthy, dirty houses, and they take the children, but everything's cleaned up and everything is okay. So you may not need for the department. Well, the department and the state have options. You know, if the parents are not in a position to resume the custody and guardianship of their children because they're not deemed to be safe, then the state of Illinois, the state of Illinois would become the guardians of the children, and they would have the discretion to either place or not place the children back home, or place them back home when the time is right.
So that's the second stage of
disposition, stage 2.
Okay. So the case is in court. We've had the shelter care hearing. We've had the petition on neglect. The judge makes a determination that there's neglect or abuse. Then at the disposition stage, the judge makes a determination that the parents are not ready to take care of the kids.
Or are ready, but you know, what to do with this family in terms of where to place the children. Where does the guardianship of the children lie?
And then what happens after that?
All right, after the disposition, then typically speaking, the parents will be in some sort of counseling or parenting classes and stuff like that. The case will be set out typically 6 months. And at the end of that 6 months, there'll be a review of the parents' progress. Sometimes, at that 6 months after that case has been disposed of, the parents have earned enough goodwill and have done enough for the children to be placed back and the case can be closed. That's a little bit rare. Usually if their progress is good and they're doing well, by that time they have the children back in their home, but DCFS is still the guardian. So they might transfer the guardianship back to the parents and then monitor the case for 6 more months.
Does it usually happen within 6 months that the children are returned?
No, it's actually quite rare that the children, I shouldn't say that. The children could be returned home within 6 months. It's still a little bit rare if it was a serious circumstance of abuse or neglect. It's very rare that a case would close 6 months after disposition. If a person enters the juvenile court system, they're going to be there for at least a year.
Wow. So what are parents supposed to do during the 6 month period of time?
Well, they're instructed what to do. They're given by the department. They'll be given by the court and the department essentially a plan of action, a case plan it's called, and it'll have tasks. So, for example, if it's found out during the investigatory phase and as it goes through trial, if it turns out that one of the problems in this house is that Dad is an alcoholic, well, Dad will have to go to treatment, submit to an assessment, and then go to treatment. If it turns out that there's domestic violence in this house, then the parents will have to go to domestic violence courses that could take 3 or 4 months and deal with domestic violence issues. If there are psychological issues, there may be a psychological assessment.
Don't people have the right to privacy in regards to any psychological issues that they have?
Oh, there's very little privacy in the juvenile court system. Once you enter the juvenile court system, your life is a bit of an open book. Now, that's within the system. You do have the right of privacy in that these hearings are closed and the rest of the world doesn't get to see them. So your neighbors can't pry into this case and find out what's going on. So in that sense, it's a private because it's a confidential proceeding. But as far as between you and the state of Illinois, no, there's complete transparency.
How do people pay for all these things that they're supposed to get done, such as?
Well, most of the people that are in the juvenile court system are not people of means, you know. That's why the public defender's office and appointed counsels probably handle 90% of the cases that are in juvenile court, and then people like me handle the other 10%. As far as the services go, if they're pursuant to court order, they're generally paid for by the state of Illinois. So you would go to the parenting class and there'd be no tuition assessed. Your job is just to go to the class, and you don't have to pay for it, or the drug treatment or any of that. Those are services that are generally provided.
Is the goal in all of these cases, what is the goal in all of these cases?
The stated goal is to reunite the family and put it in a better position than it was when it was brought into the juvenile court system. Technically, the statutory language is to cure the conditions that led to the removal of the child.
Even in cases where children are severely beaten?
Even in those cases, although the more severe the abuse or neglect, the harder it is. You know, it's entirely possible. It's entirely possible that if you fail to correct the conditions that are necessary, or that necessarily led to the removal of the children, then at some point during the review periods, there comes a point where the state has the authority of the court to file a petition to remove your parental rights. And your children will be generally either placed for adoption, usually in the home they've been in. So there's a relative or a foster family that's been ready to adopt a child.
How long does it take for the state to be able to file that kind of a petition?
They generally need 2 unsatisfactory review periods. So you figure you're going to go to court, you're going to be in the system for a year, and after that year, and there's statutory time limits that are actually in terms of 9 months, but generally speaking, your second review period, you've completely failed to do anything to correct these conditions, and it happens. You'd be surprised how some people put forth little effort to get their children back, and then the state will file a petition to terminate parental rights.
At that stage of the court proceedings, what happens? What happens at a proceeding to terminate parental rights?
The state files a petition, a document, petition, and serves upon you a petition to terminate your parental rights. In that petition, it states the grounds, and there are several grounds. The most common is you have failed to cure the conditions that led to the removal of the children. You have failed to make reasonable efforts or show reasonable interest in the child. So in that case, you may be assigned a lawyer, you may have an attorney, but you're entitled to another trial. Okay? And they have a second trial down the line. Now, and this trial is a little different because to remove your children, the state has a more difficult burden. The burden is called clear and convincing. That's the legal burden. And if you're going to use percentages, and I said earlier that 51% equals a preponderance, I generally tell clients clear and convincing is probably 75%. The state has to prove so that the judge is 75% sure that you did not meet the conditions necessary to remove to get back your children.
And forgive me or pardon me if I missed that, but what exactly does the state have to prove at that termination?
Well, they have to prove your unfitness as defined by the statute.
And what does it mean to be unfit? Is it just because you're still in Alcoholics Anonymous, or
no? If you're making progress, that's all right. It means that you haven't made progress. Examples are you've consistently tested positive for drugs, even though you've been in treatment. Fall off the wagon.
Even marijuana?
Even marijuana, yes. you fail to go to you've been instructed to go to parenting class, you've been set up, you get kicked out of parenting classes for not going, you don't show up for your counseling sessions, so you get kicked out of counseling sessions. All of these are setbacks, and if there's enough of them, and again, you have 2 graded review periods, if you have not made reasonable efforts and they don't believe that you will, then the state has the option of filing this petition and going after your parental rights.
Today we are speaking with attorney Frank Martinez, who represents parents in all stages of litigation who are dealing with DCFS. What if a parent hasn't made some progress?
Not?
Yeah, they continue to test positive for marijuana. Maybe they got kicked out of some of their classes, but their kids are deeply bonded to them. I mean, they see their kids all the time for visitation. Is a judge going to truly terminate their parental rights if there's that kind of bond?
They can. Every case is different, but they can, sure.
Does the court take into account anything outside of whether or not the parents are unfit?
Well, the court takes into account the evidence that's put in front of the court. It's up to you to put in front of the court evidence that shows that you are fit, or at least it's not in the best interest to terminate your parental rights and to continue the case to allow you to remain in counseling or to give it a try. But the statute, Juvenile Court Act, directs the court to place a high priority on what we call permanency, meaning this child has to be in a permanent home. And if it's not in its parents' home, it's going to be in an adoptive home or in the home of a guardian, where the court will send it on its way with a new family if it can't reunite with the old. So it's only going to give so much rope to the parents, and if they don't make progress at some point, they're going to sever those rights.
Outside of juvenile court, do you ever work against DCFS or with DCFS?
Well, one of the things I do a lot of are administrative appeals. Now we'll go all the way back to the beginning of what we talked about, this investigation.
Sure.
The Illinois Administrative Code has a laundry list of administrative regulations which govern the Department of Children and Family Services, all aspects of the department. Their foster parent portion, their investigatory portion, their portion that administers services and monitored cases. They're all governed by hundreds of pages of regulations. Well, in these regulations are the definition of abuse and neglect, various ways you can be abused or neglected, all the way up from the death of a child to leaving a child unattended in a house. And oftentimes they'll conduct an investigation, they'll believe that the abuse or neglect is really not worthy of bringing to court, but they feel there was an instance of abuse or neglect, or usually neglect. Something happened that violated one of these rules, but not enough to remove the children. The children are fine, they're safe, whatever happened has been corrected, but they will find that you did at one point do something. So what they'll do is they'll indicate, that's the statutory term or the government term, they'll indicate a report. And what that means is that an investigator, in consultation with their supervisor, has decided that there's enough evidence to find that you did commit this act. Again, not an act serious enough to bring to court, but you did commit this act. And this indicated report goes into a registry. The Department of Children and Family Services maintains a registry. And that registry is a list of people and what they did and is not accessible to the public. So frankly, if you're indicated for some minor thing, and you are a truck driver and you don't work with children, this isn't going to make any difference in your life.
Or what are people indicated for?
They're indicated for excessive corporal punishment. They're indicated for sexual molestation. They're indicated for improper supervision of children. They're indicated for creating an injurious environment, placing the child in an injurious environment.
Don't these cases, though, these indications, why don't they just go right into juvenile court?
Well, there's probably too many of them. There's thousands and thousands of them. I think the Illinois Department of Children and Family Services, they get somewhere in the neighborhood of about 105,000 telephone calls on their hotline. If you look at the stats, and you can go to their
Wow.
website, and they probably indicate a third of them. I can't recall now the numbers. I want to say 30-something thousand reports are indicated, and that's, a fraction of those go to court.
But why? Why don't all? If it's, say, indication for sexual molestation, why isn't this in front of one of our juvenile judges?
Because they may strongly suspect and feel that they can indicate it, that there's some credible evidence, but they don't. A state's attorney's made the decision that they don't have enough evidence to bring it into court. I mean, there's a spectrum. I mean, there's cases that are rock solid, and there's cases that are barely above a mere suspicion. And state's attorneys and DCFS caseworkers and the people in the system have to make judgments as to what can go to court and what can't.
I think you used the word appeal, administrative appeal,
Yeah.
to deal with indicated reports for
Right.
parents.
Okay, if you're indicated, you're going to get a letter. It says, we are indicating you and we're putting your name on this registry. If you try to work at a daycare center, they're going to run a check, because any business that involves children has access to this. They'll see you've been indicated for something. Well, that's like having a black mark, and you probably won't get that job. If you go to work for a trucking firm, you're not going to have a problem. So you get this letter, and this letter says you have 60 days to file an appeal. Well, filing an appeal is just writing them a letter saying, I appeal this, I disagree with this. It's very simple. And immediately that'll go to, within the Department of Children and Family Services, there's an administrative hearings unit. And this is the unit that hears your appeal. And your appeal is set before an administrative law judge, which is generally an attorney that's been deemed fair, qualified enough to sit as a trier of fact. He's not a judge in the sense that he has a robe that you see on television in a courtroom. He's an administrative law judge, is a person who has been given the authority or ability to make decisions overruling the department or endorsing the department. And a hearing, the hearing you request is a quasi-formal or semi-formal hearing, generally held in a conference room, with the administrative law judge at the head of the table, the DCFS attorney. There's an attorney that represents the department, and then you that represents your client. And this hearing is informal. There's a lot of evidence that wouldn't get into a juvenile court, into a court that gets into an administrative hearing, because the rules of evidence are far more lax. And both sides present their case, and the administrative law judge decides if there's sufficient evidence to keep this case indicated or to overturn it and remove it, which happens quite frequently in my.
Oh, really? How often does that happen?
Well, I don't have statistics. I'd love to see a statistic on how many cases that go to an administrative hearing get upheld or overturned, because I've won 11 of my last 13.
Congratulations. That is impressive.
Well, I think it speaks more for how quickly the department indicates when they really shouldn't.
And are you meaning they just don't have the evidence they need in order to...
Yeah, they don't. They don't.
Remember
what I said. When the department indicates you, that just means an investigator sat with a supervisor and they decided what to do. And they said, yeah, we'll indicate it. And the appeal process starts. Well, in 11 out of 13 of my last cases, they were wrong.
So we have administrative appeals, we have hearings in front of juvenile judges. Are there any other ways that you're involved with DCFS?
Well,
foster parents?
I do. I've represented foster parents. Foster parents are a little interesting because they're not parties. Foster parents are, the children are placed with them, and they have certain rights. They have the right to appear in court. They have the right to... they don't have the right to participate. They're not parties to the case. The parties to the case, who are people that can file motions and litigate and argue in court, are the mother, the father, the guardian ad litem for the minor, the state's attorney. And they can, file motions, or all we can do as foster parents is watch. foster parents have the right to be heard. So, for example, as an attorney for foster parents, I'll file reports with the court. I can't file a motion. I can't ask the court to do anything, but I can sure tell them what I think.
What kind of reports would you file with the court?
I can file reports as the foster parent saying the department's not, I don't think the department's doing their job. I don't think if they're recommending the return home of this child, we don't think that's a good idea. This is why.
Okay.
A lot of times, you would be surprised how many times foster parents go to war with their own department, the Department of Children and Family Services. It is very difficult to be a foster parent.
And why is that?
Because you become invested in these children that get placed in your home. And when you see something happening that you don't believe is in the best interest of the minor, best interest of the child, you want to say something. And sometimes the department doesn't want you to because it may not be expedient. Or it may not be something that it sort of upsets the apple cart. Things are going smoothly. Parents they think, doing well. But here's my position. I enjoy representing foster parents, although it's extraordinarily frustrating because they have such a limited ability. But I've done things that have never been done before. For example, filing these reports on behalf of foster parents. I've never known an attorney to do that, so I do it because I want the judge to hear what my foster parents have to say. What the court often forgets, and now I'm going to pontificate a little bit. This is not legal seminar. This is my opinion. Sometimes the court forgets that the eyes and ears of the court should be those foster parents.
And why is that?
Because the foster parents get the child up in the morning, give the child breakfast, send the child to school, go to parent-teacher conferences, pick up the child from school, tend to the child when the child's sick, they put the child to bed, they are with the child 24/7. They know when the child is upset. They know when the child is happy. They know when the child is fearful. The caseworker from DCFS shows up once a month to check on the family, sees the child, says, "How you doing? Everything's fine," and then leaves. Now, if you wanted a report on what this child is going through or what's happening or what's the status, who would you talk to? 24/7 or once a month? But there's a tendency to ask the caseworker, "How's the kid?" They say fine, and the foster parents may not agree with that and want to communicate to the court, "Not so fine. There might be something wrong." And this is a difficult position for the court to be in, or a judge to be in, because oftentimes, and I've seen this, the department may place the children with a family member.
Isn't there a potential danger of foster parents being biased?
Yes, I was just getting to that. You may have a mother and a father, and the child is placed with a maternal aunt and I've seen this, and the foster parents may be very good foster parents, but may have a vendetta against one of the parties, and are just as capable of filtering inaccurate information to the court.
Sure.
Now, frankly, if they're my foster parents, before anything goes to the court, it has to go through me. And I'm not going to say anything on behalf of clients that hasn't been verified. I'm not going to let my clients, if my clients truly care about the child that's in their home, then I will litigate on their behalf.
How do you verify a statement by a foster parent who says the child is, say, afraid of their biological parent?
All you can do is inquire what makes you say that. and try to assess the credibility and then present it to the court for the court to assess. You can't go to your client's house and talk to the kid. First of all, you can't talk to the kid because the child has an attorney as a guardian ad litem. It wouldn't be my place to go interview a child. I could talk to the guardian ad litem and say, look, this is what my people are saying. You should check into it.
Well, Frank, I really appreciate you speaking this evening with us.
Thank you for allowing me to be long-winded and verbose.
Far from long-winded. Your practice is based in Rockford, correct?
Yeah, 308 West State Street.
308 West State Street, and if people need to contact you for, say, whether it's foster parent representation or representation in juvenile court, what is your office phone number?
815-964-7933.
Just to kind of sum up, is there any, summary advice you can give to parents who find themselves in a situation with DCFS knocking at their door?
Contact an attorney and seek counsel, because you don't want to take any missteps. You may accidentally find yourself doing yourself more harm than good. The state of Illinois has rights that you probably don't know they have, and if DCFS or any other state agency knocks on your door for reasons that you don't like, the first thing you should do is find an attorney that practices in that area, like this area, and make sure that you have a guide so you don't step on any landmines.
Well, thanks again, Frank. We appreciate you being here.
Thank you.
You just heard a phenomenal episode of Divorce Talk Radio. Listen to Divorce Talk Radio live on RockfordCollegeRadio.com Tuesday evenings at 8 p.m. To hear more of Divorce Talk Radio shows, please visit RockfordCollegeRadio.com. To learn more information about attorney Brad Tangler, please visit TanglerLaw.com.